So I want to keep talking about what assets, if you're trying to avoid probate and make it simpler for your loved ones to get your assets when you pass away, and not have to go through lawyers and courts to simply, make that transition of what you have to your loved ones. What other assets should go in your what's commonly referred to as your revocable living trust? Well, certainly your real estate should. That real estate gets frozen if it's in your name when you pass away. You got to go through the courts to get it transferred. But there's other assets that people typically have, and this isn't a full list because there's so many different types of assets, but just some common ones. A lot of people own what's called a membership interest in a limited liability company, also known as an LLC. Either they own a business or their rental property or other properties in an LLC, and maybe they own 100% or maybe they own 25% of the LLC. Well, whatever membership interest they own, if it's in their name when they pass away, it'll take court orders to transfer their membership interest, to their heirs. So you can transfer that to your living trust, and then the successor trustee can put that membership interest in your beneficiaries' names, literally the day after you pass away, without having to go through the court process. So LLCs, small businesses, interests are one asset. Another common one is if you own stocks or bonds or mutual funds in your name, or maybe in a joint account with a spouse or someone else. Those are going to be frozen when you pass away. I'm not talking about stock that you own inside of an IRA, individual retirement account, and that IRA has a designated beneficiary. I'm talking about other individual or joint investment accounts outside of your retirement account. Those accounts, if they're in your name when you pass away, they'll be frozen. It's real easy for the brokerage firms or the financial institution to retitle that account into the name of your living trust. Once your trust is established, they'll have to have certain documents in their files indicating, the necessary trust provisions. So stocks, bonds, mutual funds, mineral interests here in Louisiana are common. So those, again, need to be in your trust. If they're not, you're going to need a court order to get those things retitled into your heirs' names. So there's some other things as well, but those are the real common ones: real estate, business interests, stocks, bonds, mutual funds, those kinds of investments that might be in your name. So just, again, work with your estate planning attorney to make sure that everything that needs to go in your trust gets in your trust, so you're not left with your family having to go through that probate when you pass away. If you want more, go to our Facebook page, Rabelais Estate Planning LLC. That's our law firm's Facebook page.